Good morning, good afternoon, good evening. My name is Martin Reggie, and I'm an Associate Program Officer within the United Nations Office on Drugs and Crime, UNODC, specifically in the Terrorism Prevention Branch's Chemical, Biological, Radiological, and Nuclear Terrorism Prevention Program. Firstly, I would like to thank and welcome participants to today's webinar. I'd like to convey UNODC's gratitude to the European Union for enabling this important activity and for its crucial contribution to the promotion of the International Convention for the Suppression of Acts of Nuclear Terrorism, otherwise known as ICSANT, through the EU-funded project on Union support for the universalization and effective implementation of ICSANT. Today is the second of 10 planned webinars on various key aspects of ICSANT. As you may know, ICSANT is an essential tool for preventing nuclear and radiological terrorism and improving nuclear security worldwide. It contains essential provisions dealing with international cooperation in criminal matters related to the offenses it establishes. ICSANT can benefit all states parties by facilitating international cooperation, including the exchange of information on radiological and nuclear terrorism, threats, and prosecution or extradition. Today's webinar focuses on extradition and mutual legal assistance in the context of ICSANT. UNODC, through its CBRN programming funded by Canada and the European Union, assists member states by building the capacity of criminal justice officials, including prosecutors, frontline officers, judges, and others as it relates to ICSANT. Extradition and mutual legal assistance are key tools when it comes to prosecuting criminal conduct involving nuclear or other radioactive material. ICSANT and the material it covers present particularities in relation to criminal proceedings, inter alia with regard to evidence gathering, evidence preservation, and admissibility, as well as international cooperation. Very soon, you'll hear from Mr. Simon Minks, the National Coordinating Advocate General, Counterterrorism, Violent and International Crimes, Senior Prosecutor in Appeal of the Netherlands. But before that, let me begin by providing you a brief primer on ICSANT, and apologies to those who joined our first webinar, as this will be the same presentation, but you'll hear about a very exciting new topic from Simon in just about 5 minutes, so please stay tuned. And with that, I will just give you a very brief primer on ICSANT. So, as mentioned, today's webinar will focus more specifically on extradition and mutual legal assistance in the context of ICSANT. I'll start just by sharing very briefly a quote from our Executive Director, Ms. Gadawali, that highlights the work that we do within the CBRN Terrorism Prevention Program at UNODC. Specifically, we work to promote universalization and effective implementation of the counterterrorism instruments, which includes ICSANT. So you can see that's a two-headed approach, both universalizing the instruments and working for their effective implementation. Little history on ICSANT. Negotiations were called to address gaps in the legal framework for preventing and responding to acts of nuclear terrorism. As such, ICSANT was drafted by an ad hoc committee established by the UN General Assembly in 1996. The convention was adopted then by the General Assembly in April 2005 and opened for signature in September 2005. It entered into force on the 7th of July 2007, and the depository is the UN Secretary General. As mentioned, there is an international legal framework against terrorism comprised of 19 instruments, of which ICSANT is one. These instruments all follow a similar structure. Specifically, they criminalize certain acts. They set up instances of jurisdiction, both mandatory and optional, and they include the principle audere aut judicare, or extradite or prosecute, and they help to facilitate international cooperation through various mechanisms. ICSANT establishes offenses involving radioactive material, radioactive devices, or nuclear facilities where they've been committed unlawfully and in the absence of legitimate justification, that is, intentionally or deliberately. These offenses range from illicit possession or use of nuclear or other radioactive material or radioactive devices to damage to nuclear facilities, and include also a series of ancillary offenses. The list of offenses to be criminalized pursuant to the convention can be found in its Article 2, and you'll find them listed there. It's important to know that in order for an offense to fall under ICSANT, it has to be committed with a specific intent, and also there has to be a transnational element to it. Those offenses those intents include to cause death, serious bodily injury, or substantial damage to property or to the environment, or the intent to compel a natural or legal person, an international organization, or a state to do or refrain from doing an act, the so-called terrorist intent. And I'll just highlight there was a briefing yesterday by the UN Security Council's Counterterrorism Committee, specifically on the criminalization of terrorist acts. That is something that's recorded and available on UN TV. So I would encourage you to check that out as well. It was a fascinating topic and very timely. States must criminalize these acts under Article 2 and make them punishable according to their grave nature. That can be through a variety of different ways. States must also establish jurisdiction under ICSANT's Article 9, specifically instances of mandatory jurisdiction, as well as some cases of optional jurisdiction. And the obligation of extradite or prosecute, together with jurisdiction provisions, aims to allow as many states as possible to prosecute the offenses and prevent legal loopholes to be exploited and to deny the creation of safe havens. So the criminalization provisions coupled with that principle of auditore ad judicare seek to accomplish that. You'll find a list here of the different international cooperation mechanisms within ICSANT. So specifically today, we'll just be focusing on those first two. These provisions seek to facilitate and enhance international cooperation in criminal matters among states parties, including extradition, mutual legal assistance, for example, the exchange of evidence, the exchange among states parties, and with competent international organizations of relevant information to prevent, detect, suppress, and investigate offenses under the convention. This is done through competent authorities and specific liaison points. State parties are also required to cooperate by taking all practicable measures to prevent offenses under the convention, including by enacting appropriate legislation giving effect to those criminalization provisions under Article 2. Here's just very briefly a list of the benefits of adherence. So you can see under the third check mark, this facilitation of international cooperation, which extradition and mutual legal assistance seek to accomplish. This is our UNODC ICSANT website. You'll find all of our materials and resources there. Please visit it. I won't go into detail now, but really a lot of resources available. Just quickly, a recently launched tool which may be of note to you or of use is a repository of national legislation for various nuclear security instruments to implement the criminalization provisions of them. One of those being ICSANT. So we've gathered different laws and regulations by states parties on how they implement their obligations and the offenses under Article 2 of ICSANT. Also, some other training tools include our broader Module 6 on the CBRN legal framework, a manual of fictional cases specifically on ICSANT, and a more recently launched guide along with UNICRI, the IAEA, the International Association of Prosecutors, the Joint Research Center of the European Union, and UNODC, a prosecutor's guide to radiological and nuclear crimes. And Simon also contributed to that, so he'll talk about that in a little more detail in his presentation. And with that, I will now get to the exciting part of today's webinar. Mr. Simon Minks, who will be speaking today. You will remember Mr. Minks again from our first webinar back in April on a prosecutor's perspective on ICSANT. A longtime friend of the Terrorism Prevention Branch of UNODC, Mr. Minks has specialized in counterterrorism and war crimes since 2005. He served for many years as liaison magistrate with the International Criminal Court, the Mechanism for International Criminal Tribunals, and various embassies. Prior to his current position as a senior public prosecutor, Mr. Minks was a practicing lawyer for 10 years. Throughout his career, Mr. Minks has prosecuted highly sensitive cases, including many involving national and international terrorists. Mr. Minks gives trainings and presentations for judges, prosecutors, lawyers, and policemen worldwide, and guest lectures at national and international universities. In fact, I think he's giving one today, right after this. Following Mr. Minks' presentation, we'll have a brief Q&A session. So if you have any questions, please email them to unodc-icsant@un.org, and we will attempt to answer them during the allocated time at the end of the webinar. Simon, I'm happy to hand the floor over to you. Please proceed. I'll pull up your presentation and we can get started.
All right, thank you very much, Martin, for your kind introduction. Thank you also for the organizers for having me in this important webinar. I would like to say good morning, good afternoon, good evening to all of you from all over the world. I understand from Australia to the US, to North Africa, to Nigeria. All welcome. I'm very happy that you take the time to watch this webinar. And I'm also aware about the fact that most of you don't have a legal background. But nevertheless, if you are somehow involved through the Ministry of Foreign Affairs, through the National Forensic Institute in the Netherlands, for instance, or otherwise, we have to work together when something occurs related to the ICSANT. And that's where I'm going to say a few words about that. And maybe we can go to the next slide to start with. Not so long ago, as you can see, a couple of weeks ago, the International Atomic Energy Agency Incident and Traffic Database, remember that name, reported that 31 countries, 168 incidents in which nuclear or other radioactive material was lost, stolen, improperly disposed, or otherwise neglected last year. And that is in line with historical averages. And the watchdog also recorded that more than 4,000 thefts or other incidents over the past 30 years took place. So the topic we are speaking about today is a really actual one. It could happen to everyone, and it's not only about stealing this kind of stuff, but it's also about the lost stuff that could cause all kinds of dangerous situations, also in countries where there is no nuclear facilities. But as you can see in the example I will provide later on during this presentation, it could affect your country as well. So let's go to the next slide, please. Before I go further, I forgot to say that in the blue line that is underlined, that is the source of the slide. So if you want to read something more about the background of the slide, you can go there. So in this particular case, it's from www.stimson.org, and there you'll find information about, for instance, the joint statement of the International Conference on Nuclear Security, ICONS, a couple of weeks ago. And that emphasized that any attacks or threats or attacks against nuclear facilities devoted to peaceful purposes may compromise nuclear security. That sounds logic, but I think it's very important to realize that. And it expanded on the 2020 Declaration on Other Notable Ways. And it's also included the recognition of the potential challenges and the benefits of emerging and innovative technologies and the importance of nuclear security considerations in advanced nuclear technologies and reactors. Now, I am just a simple prosecutor, so I'm not very familiar with all these technical stuff, but nevertheless, I have to work with that if it comes to a prosecution. Probably most of you are familiar with this. However, I'm trying to say something about the way the approach of the prosecutor, it could also be the investigator, depending on your legal system. Some of you are from a common law system in which the police is really conducting the investigation. Others, like myself, are from a civil law tradition in which the public prosecutor would be in charge when it comes to the investigation itself. So let's go on to the next slide, please. So Martin already mentioned a couple of things from the previous webinar, but nevertheless, I would like to refresh your memory if you have forgotten that or somehow wants to repeat it anyway. ICSANT is a very, very, very important treaty. But you have to know that there is a scope of application of ICSANT which might be limited in your view, but nevertheless you have to realize that. So it is limited to offenses that have a transnational element. And this convention is not applicable with some limited exceptions if all the following 4 circumstances are met. And you can read them on the slides. It is committed within a single state. The alleged offender and the victims are nationals of that state. The alleged offender is found in the territory of that state, and no other state has ground to exercise jurisdiction. So if you think that ICSANT can be useful in your particular situation, in your country, please take a close look at the scope of the application of ICSANT. Important for you to understand that it is transnational. Also important is that the state parties shall criminalize the following conduct, provided that they are, of course, unlawful, maybe most important, intentional, and even more important, there must be a specific intent. So for the lawyers between the watchers, under the watchers, realize that it must be intentional and specific intent. Okay, let's go on to the next slide, please. Now, Martin also draws some attention on Article 2. Actually, it is, from my point of view, from the prosecutor's point of view and the investigator's point of view, it's the most important article. I'm not going to that to the whole article because it's the previous webinar, and you can find it on the website again. But it is about possessing radioactive material with the intent. There you have again the intent to cause, you know, any of the following, and then you see what's happening. It's also about the making a device with the intent. It is possessing a device also with intent. So it's always about the intent, but it's also using in any way radioactive material with the intent to cause, etc., etc. Please realize that the possessing, the making, you know, the using, it could also be covered, always covered by the ICSANT Article 2. Okay, to the next slide, please. And as you can see here, it's much more than that. It's also about threatening. It is about attempting to commit an offense. And it's also about organizing or directing others to commit such offenses. The intentional contribution, either in order to further the crime or being aware of the group intention to commit it, is also within the scope of Article 2 of ICSANT. So there is a lot of, a lot of possibilities covered by this Article 2. So if a situation occurred with radioactive or nuclear material, lost or stolen, you must find out by focusing on Article 2 whether it is covered by this Article 2, and you will see that most of the imaginable situations are covered by this very much important Article 2. Okay. So, next slide, please. We're talking about the cross-border crime. And let me share some information about evidence. My job as a prosecutor is about collecting evidence, and it must be admissible in court, of course. And as I said, prosecutor is not that familiar with cases related to either chemical and biological or nuclear or radiological crimes. So he must realize, or she must realize, that if he is starting an investigation, and the same goes with an investigator, it must fit within the framework of the national code. And as you can see, this is the national code in the Netherlands, the national provision 339. And you might see that what is allowed as admissible evidence would be almost the same in every country. It's about the court's own observations. For you, important to understand, because I guess most of the audience is an expert or related to an expert. Also, the statements of an expert witness is allowed under certain circumstances and admissible in court. Okay, let's move on to the next one. I am a counterterrorism prosecutor, so I'm dealing with counterterrorism and also dealing with other international crimes like genocide, crimes against humanity, and war crimes. So how do we generate evidence more in general when it comes to these kinds of crimes? These are on this slide the most traditional ways of getting evidence. You know, information from the local police, from the border patrol, from friends, from witnesses, the local community, from churches, from mosques. But I would like to draw your attention more specifically on the evidence coming from abroad, because in counterterrorism cases, and you know, ICSANT is about nuclear terrorism, a lot of evidence is coming from abroad, and that is putting us in some troubled water sometimes, because the rules are not that clear every time to deal with. So let's go to the next slide to elaborate a little bit more about that. So if I'm talking about evidence collected from abroad, that could be evidence collected by foreign investigative authorities, you know, from other police that, who is conducting an investigation in another country, collected the evidence and sent it to me as a prosecutor so I can deal it, I can use it in court. But also the non-governmental organization could also collect and also share some evidence. Civilians, battlefield evidence coming from the military on a national but also an international level, other countries, as I said, the information and also evidence could come through Interpol or Europol and also Eurojust. I think you're all familiar with that, with Eurojust as well. It could also in the form of a joint investigation team, or, and there it is, or within the framework of ICSANT. And I come back to that later during this webinar. So let's go to the next slide. So this webinar is about international obligations. Let me start with some more general observations about international obligations. And please forgive me if I am saying something you already know, but I know there are also people with another background than a legal background, so probably it would be useful for you to understand. Important, and the first thing I would like to stress, is the Security Council Resolution 1373 from 2001. And that resolution specifically decides that member states shall, and there it is, ensure that any person who participates in the financing, the planning, etc. Of terrorist acts or in the supporting terrorist acts is brought to justice. And furthermore, that resolution decides also that all states shall afford one another the greatest measure of assistance in connection with criminal investigations or criminal proceedings. Now, I will tell you no secret, I guess, that this is the theory. In practice, it's not always that easy to work together with other countries, to go through all these regulations related to international obligations. And there might be an obligation, but somehow it is not working out. But please realize that we are talking about the most serious crimes we can imagine. And therefore, this resolution is a good start to realize. Okay, let's move on to the next slide, please. I already mentioned Eurojust, based in The Hague. That is a very important organization to work with, also for countries outside Europe, because they have a cooperation within the European Union with a lot of countries. A lot of magistrates are assembled over there, and they identified the following priority areas. The timely coordination of counterterrorism investigations. Timely is an important word. and the prosecutions to help render EU member states' investigations and prosecutions successful. And as you can see, the third bullet point also, the coordination of the judicial cooperation to provide support to victims, let's not forget the victims, of terrorism and guarantee their rights. Also important, there is a lot of experience on board over there. The sharing of experience and input to discussions at the EU level concerning judicial cooperation. And as you can see also, similar in the ICSANT treaty, the exchange of information on terrorist offenses and challenges, and also the best practices in the judicial response to terrorism to address the evolving nature of the terrorist threat. And I think it goes without saying that if we are talking about a nuclear threat, a lost radioactive device, we are talking about a serious situation, and the exchange of information must be very quick. Last but not least, I also want to mention the genocide network, who could also provide some information. So coming back to the countries outside Europe, if you have a case in general, but also related to this topic today, related to the EU, please remember that Urius could also provide you with some help, with some coordinating meetings in this regard. Okay, let's move on to the next slide, please. So if we are talking about international cooperation, for those who have not a legal background, we can speak about the bilateral and the multilateral arrangements. Agreements to prevent and to suppress terrorist attacks and to take action against perpetrators of such acts. Also related to extradition, the international counterterrorism instruments requires that states in that regard would cooperate with one another and to make terrorist offenses extraditable and to submit terrorists for prosecution if they are not to be extradited. And I'm referring then to the United Nations Global Counterterrorism Strategy and also to its action plan. Now, as I said before during this webinar, you have the theory in which states are obliged to work together and the practice. I am an operational public prosecutor, and I unfortunately experienced that even in cases where there is an obligation to cooperate, it's not that easy that you get the information you want for your in order to get a successful prosecution. So the international cooperation is not that easy. This is the theory, but you have to work on it. Let's go further, please. And the same goes for the mutual legal assistance. I mean, talking about the ICSANT topic, the radioactive or nuclear material, you must act quickly and it must also be effective. So there must be somehow an effective cooperation with each other. And also to assist in every way other countries to prosecute, in order to prosecute successful terrorism cases related to this. In accordance with, of course, international, but also domestic law. And as you will see later on, also ICSANT has this element of complementarity. I will come back to that later. Also important to understand and to realize is that member states are enhanced to coordinate cross-border and joint investigations when it comes to terrorism cases, because most of the terrorist cases I'm involved with, or I'm familiar with, are transnational crimes. So anyway, you have to work together with other countries as well. So you have to invest in mutual legal assistance as well. Okay, let's move on. Now, what kinds of assistance do you have? For those who are not familiar with it, of course, you have the mutual legal assistance. You have letters of rogatory. You have the international assistance. And it could be formal or informal. What do I mean with that? The prosecutor's world is not that big, but nevertheless, sometimes we are surprised by situations. When it comes to an extraordinary situation, we are not familiar with that. We can reach out in a formal way, but we can also text each other, for instance, through WhatsApp, to ask colleagues what kind of experience they have and what kind of advice they would give in such a situation. So formal and informal. Of course, when you start informal and you are going to use that information as evidence, you have to make it formal anyway after that. But just to make sure that you can start also in an informal way, and it has its benefits as well, especially when you have to act fast. And in counterterrorism, you have to act fast. It is very beneficial when you can also act in an informal way. Okay, let's move. So I mentioned already the bilateral and the multilateral basis. Then you have the subject and the specific legal basis. And let me give you an example. For instance, the UN Convention Against Transnational Organized Crime, UNCTOC, could also be a legal basis. And then I go to the next slide just to give you an example of that. For instance, this article of the previous treaty I discussed. And there you see in this Article 1 that the state parties shall afford one another the widest measure of mutual legal assistance in investigations, the prosecution and the judicial proceedings in relation to the offences covered by that convention. So you would see in other likewise treaties, more similar provisions, you have to work together. And again, you have to make clear sometimes to the other state parties what the obligations are. So you have to discuss that when you are not a prosecutor. You have to discuss that with the prosecutor or the investigator, how to do that. Now, we need tools for that. And the UN provides us with a couple of tools. And Martin was already in his introductory talk mentioning some of them. We have some model treaties, as you can see, the model law, the mutual legal assistance request, right tool, and we have ICSANT. Okay, what about ICSANT? Next slide, please. The ICSANT treaty requires states parties to cooperate also in order to prevent. And please keep that in mind. It's not after the event, but this is about prevention. And that makes this ICSANT treaty also very important for you to consider if you are not a member of that, to prevent and counter preparations for the commission of offences inside or outside their territories, but also to ensure the security and the safety of the radioactive material, the facilities or the devices seized by state parties following the commission of an offence. So this is about prevention and also ensuring security. So it is reaching out to all of you because every country could be affected by the topic we are talking about in this webinar. Please go to the next slide. And ICSANT obliges state parties to designate a national competent authority, and I think that in most cases, in most countries that is already the case, a liaison point responsible for the exchanging of the relevant information covering this topic. But I guess most of you countries where you are from have already this national competent authority to deal with. Okay, to the next slide, please. It's not only about mutual legal assistance, it's also sometimes about extradition. What is extradition? Extradition is the formal process whereby a state requests from another to return a person accused of, convicted of a crime that sent trial or serve a sentence. Also related to nuclear terrorism. So maybe we can go on to the next slide to give you some more details about when we are talking about extradition. Just to give you some background information, we have the situation of the double criminality that is necessary, which means that it must not only be a crime in the country you are dealing with, but also in your own country. So if you want to extradite, you put forward a request to extradite someone to your country. These are some of the requirements that must be taken into account. And I'm just touching upon some of them. The double criminality is one of the most important things. So remember, it must be a crime in the requesting state as well as the requested state. And then the third bullet point, the non-extradition of nationals, I have to to say something more about that, because that's the general rule. However, in daily practice, sometimes nationals are extradited when there are some conditions met. For instance, that there will be no death penalty at the end, in combination of when someone from your own country has been extradited to another country to stand trial over there. He can also serve part of the time of the sentence in his own country. So it's not that strict as here on this slide, but this is more the general rule. There are some exceptions, of course, when it comes to extradition, like the political offense exception. I guess you're all familiar with that. And also important for you, that's more a legal issue, is the double jeopardy, what we call the nevis in idem, that you cannot be prosecuted twice for the same fact. So please keep that in mind when you are confronted with an extradition topic. Okay, let's move on to the next slide. So what about nuclear terrorism and extradition in this combination? Please remember that member states and their obligations are there to ensure that any person who participates in the financing, planning, the preparation, also from this kind of crimes, has to be brought to justice. And the same in the ICSANT treaty is emphasized here, that member states of their obligation must avoid the situation that your country will become a safe haven for criminals. Not only ordinary criminals, but also for war criminals, and also criminals who are dealing with the ICSANT topics, nuclear and radiologic crimes. So you have to do something with that. Please remind also that the member states and their obligations to extradite or to prosecute under the applicable international counterterrorism instruments to which they are parties, and their obligation to ensure in conformity with the international law that claims of political motivation are not recognized as grounds for refusing requests for extradition of alleged terrorists. Now, I realized I am launching a lot of words to you, but please try to remember as much as you can. And if you are confronted with such a case, no matter whether you are a forensic expert or a representative of the Foreign Affairs Ministry of Foreign Affairs, that these are more the basic issues you have to talk about, or you can talk about with the investigator when you are living in a common law system, or with the prosecutor when it comes when such a situation occurs in a civil law country. Okay, let's move on to the next slide, please. Now, the extradition and ICSANT. The state party in which the alleged perpetrator is present must be either extradite or prosecute, and that's more a legal principle, as you remember from the previous slides. And the ICSANT, more particular, the ICSANT requires that offenses under the convention are deemed as extraditable offenses in any extradition treaty existing between any of the state parties before the entry into force of the convention. But it also provides that state parties undertake to include such offenses as extraditable offenses in every extradition treaty to be subsequently concluded between them. So this is more specific when it comes to extradition in relation to ICSANT. Let's move on to the next one. So I hope you can still read this slide, because I need some other classes for that as well. So why should you join and use ICSANT? Why? I mean, there are so many treaties already available. But is your country you are representing already a member of these treaties? And why joining and using ICSANT? Let me give me some of the benefits of that. ICSANT has a deterrent effect and reduces the risk of impunity of offenders by denying them safe havens. Okay, but it's also strengthening national, regional, and also global security. Of course it is about security. But the convention also facilitates the international cooperation in criminal matters. And that's where this webinar is about. So it's facilitating international cooperation in criminal matters by facilitating the extradition I was just mentioning, but also the mutual legal assistance and the information exchange, because you want to know as soon as possible when someone crossed your border with a nuclear device, because it's really affecting your security. And you want to know that immediately, not after months. And being a party to and implementing ICSANT contributes to the state's compliance also with the previous mentioned binding Security Council resolutions and also other resolutions mentioned on the slide. And again, please realize that this ICSANT treaty is complementary to other legal instruments against nuclear terrorism, including the Convention on the Physical Protection, for instance, on nuclear material, and also its amendment in 2005. ICSANT is broader in scope than these instruments, as it covers not only the nuclear material, but also radioactive material, and it applies also to nuclear material and facilities used or retained for both military and peaceful purposes. And it contains a broader definition of nuclear facilities. So it is much more than just a nuclear device or something like that. If you believe it's not necessary to join ICSANT because we are already parties of another treaty, please make sure that they are using the same broad definition as used as in ICSANT, because I can guarantee you ICSANT can provide you with much more provisions than you will find in the other treaties. Now let me give you an example, and it's pure fictional, just to give you an idea how it is working. Let's assume that there is a truck, and the truck is transporting radiotherapy equipment containing a cobalt-60 isotope, and it has been found in country B after it was stolen in country A. At the time the truck was stolen by a national of country A, the source was properly shielded. The main concern of the authorities at that time was that the radioactive isotope, cobalt-60, in the stolen truck is dangerous to handle. The material could have been used to make a radioactive dirty bomb. And I'm not sure whether everyone knows what a dirty bomb is. A dirty bomb contains radioactive material, but does not use that material to produce a nuclear explosion, as it is in the case with a nuclear weapon. But nevertheless, it is imposing fear in your society. So it is really affecting your security as well. Now, as with any explosion, people in the immediate vicinity could be killed or injured by the blast itself of such a dirty bomb. The dispersed radioactive material could lead to exposure of people in the same vicinity. And the thief of the radioactive material, in this fictive example, is a strong supporter of a terrorist organization in that other country, in country B. But he was arrested in A, country A. But the other involved persons, the other terrorists, if I may say so, are arrested in country B. And what if both countries are members of ICSANT? Let's see. The next slide, please. First of all, there is no discussion about jurisdiction. That's more a legal issue, so I leave it for now with that, with the legal experts. But important for you to understand, either if you are working in the security business or the foreign affairs or in the forensic affair, for you and everyone, the fast and timely exchange of information flow is extremely important. The international cooperation, of course, between A and B, if you can imagine, is extremely important. You want to know immediately if the truck is crossing your border, entering your premises, and causing some danger for all the people in the vicinity. Now, in this particular case, A could be extradited to B in an easy way where the trial took place. because they are both ICSANT countries. If they are not ICSANT countries, the extradition, for instance, could cause a serious legal obstacle, because why should we extradite our nationals to another country? And why couldn't we also conduct our own trial? From the legal perspective, it is important, and also within the scope of ICSANT, to have most of the perpetrators involved in such a case at trial in the same country. So the benefits of being a member of ICSANT in this particular case is that the fast and timely exchange of information, so you can act from the security perspective, you can prevent that the dirty bomb will be exploded. The international cooperation, but also the possibility in an easy way to extradite someone from another country who is also a member of ICSANT to your country. So you can start your own trial with all the perpetrators in the court. So this is a simple example, of course, of why you could use ICSANT and be a member of ICSANT, because it's giving you a lot of benefits. It is, as I said also in this example, facilitate in an easy way the international cooperation, not only in criminal matters in general, but also when it comes to nuclear and radiological crimes. It lays the basis for the international cooperation for the secure and the safe handling of radioactive material facilities or devices, which comes under the control of state parties after an offense is committed. And also being party to and implementing ICSANT contributes to the state's compliance with the relevant binding Security Council resolutions, including the previous mentioned Security Council number 1373, but also 1540 and 2325. For these people, for the watchers who are working in the Ministry of Foreign Affairs, please take a closer look at these Security Council resolutions, because it's not only a free right that these Security Councils are there, but it's also having some obligations for all of us. Okay, let's move on to the next slide, please. So I already mentioned the term complementarity. And complementarity means that it is, adding to other assisting legal instruments against nuclear terrorism, including the previous mentioned Convention on the Physical Protection of Nuclear Material and its amendments. And it is more important, also broader in scope than these instruments. So it is covering much more. It makes your country more safer. It covers not only the nuclear material, but also radioactive material. And it applies to nuclear material and facilities used or retained for both military, but also peaceful purposes. It contains this broader definition of nuclear facilities. So it could be useful, from my perspective, for every country. Okay, let's move on. So you might wonder, if you are a prosecutor or an investigator, how do we deal with this complex material? There are a lot of other issues to be discussed when it comes to ICSANT-related topics, like the communication between experts and investigators, experts and prosecutors, and also the language which is used by experts when they are trying to explain what happened in that particular case, and how do we deal with that as prosecutors? Because as prosecutors, generally speaking, we are not trained for these exceptional cases. Maybe exceptional, but imaginable nowadays, unfortunately, in an increasing dangerous world where not only radioactive and nuclear material is stolen, but it could also be lost, causing also a dangerous situation. How do we deal with that as prosecutors? You might be wondering. But luckily for us, and maybe we can go to the next slide, and also for others who are interested in that, there is this recently launched new guide. The Prosecutor's Guide to Radiological and Nuclear Crimes. And as you can see, it's a cooperation between a lot of international organizations like UNICRI, like UNODC, like the International Association of Prosecutors. We all work together on this particular guidebook, which informs more in general, not only the people who are in charge within the Ministry of Foreign Affairs, within the security services, but also offers investigators and prosecutors a guidebook how to deal with this particular kind of cases. And last but not least, I also would like to emphasize that UNODC is also offering some workshops how to practice this, how to practice a situation in which ICSANT could be applicable, and how to deal from the crime scene to the courtroom with all these stuff, with all these legal stuff, this other forensics challenges. So if I may use this opportunity, I would recommend to take a closer look at the offering of this UNODC workshops to practice and to work together, if you are an expert, with a policeman, and to work together with a judge. How are we fitting with each other in these particular cases? So training is needed, absolutely, for all of us, I believe, especially when it comes to the cooperation between all these different actors from the field, from the court, but nevertheless, you have some guidebooks to use in this particular case. So that brings me, I guess, to the end, Martin, of this, very brief webinar. I tried to give you an overview of the most important things related to international cooperation, the mutual legal assistance, the extradition issues, when such a situation occurs in your country. And again, it's not necessary that you have a nuclear plant in your country to become a member of this treaty, but just this treaty, realize that this treaty is there, and it is offer you a lot of possibilities to avoid impunity and also to bring the perpetrators to justice. With that, I leave it. I would like to thank you very much for your attention, and I'm open to all kinds of questions. Back to you, Martin. Thank you.
Thanks so much, Simon. I really enjoyed your presentation. It appears that you're frozen, at least from my end, so I don't know if you can shut off and turn on your camera, but we can hear your audio okay in the presentation we were able to view. But right now we'll just proceed to a very brief Q&A before the hour is up. I have mentioned you have the ability to send in your questions to unodc-icsant@un.org. But before we wait for those to come in, I have a couple of questions of myself. So Simon, just right off the bat, what makes for effective mutual legal assistance, and how can ICSANT help to facilitate these requests? And I guess that would be twofold. What makes for effective mutual legal assistance from a requesting country and from the country providing it as well, because it really is there are two parts to that. So over to you, Simon.
Yeah, thank you very much, Martin, for these important questions. I think foremost, ICSANT is offering you a fast track in information exchange. I mean, if you are confronted as a country with an offense related to ICSANT, you want to act very fast. And ICSANT is offering you a lot of legal instruments. And if you are dealing with another ICSANT member, you would really appreciate that that other country is also informing you that, a couple of minutes ago, a truck with a radioactive device is passing your border in an illegal way. So it is somehow facilitating the international cooperation in a much better way, from my personal opinion, if you compare it with some other treaties also related to international cooperation. Because what I would like to emphasize is that there are a lot of theoretical international obligations, but working together in actions can make the difference, in preventing a really serious situation. And in my example, I reached out to a dirty bomb. But, you know, and also when it comes to extradition, you see these extradition process could be much faster than if you only have bilateral extradition regulations or, you know, a mutual extradition regulation. Because in every case, that's my experience as prosecutor myself, it could take a very long time to get someone extradited to the country where this trial is started. So it's offering all of us so many benefits. So I really strongly recommend at least to take a look at the provisions of ICSANT and, if possible, to join ICSANT as a member.
Thank you, Simon. And just building off of that a little bit, I would think that things like common definitions within the convention would also be quite useful when you're talking about cooperation across jurisdictions, across states parties, to again help facilitate those requests for mutual legal assistance.
Yeah.
So I have a second question for you here, and this one relates to the other topic of today, extradition. You've obviously mentioned you've dealt with extradition requests previously. What are some of the main obstacles to those requests for extradition, and how can ICSANT help to overcome some of those obstacles?
Well, first of all, thank you very much, Martin. First of all, you might remember the slide where I described some of the issues that in general could play a role in extradition cases, like the double jeopardy, the dual criminality. When I put forward an extradition request in an ordinary case, it will take a long time to get someone extradited. And as I said, the general rule is not to extradite nationals. And of course, there are also in daily practice, and not only in cases related to ICSANT, there are exceptions. But the thing is that the ICSANT treaty provides everyone the possibility to do it much faster. We are all familiar with the topic. We are a member state, and the extradition would take place under these conditions, as mentioned in the ICSANT treaty as well. So it is offer you a fast track to start a proceeding in your own country, while in other situations, like the example I gave, you have to wait for a very long time to get someone extradited who also played a part in the plot. So, you know, if you start a trial, you want all the actors in court and all related to the same topic. You don't want any delay. So that's one of the benefits. If you are a member of ICSANT, you can do that much faster than if you are not.
Thank you, Simon. And just again, building off of that, a couple of key points as well with an ICSANT. You highlighted obviously the language which deems certain offenses as extraditable, and also includes future extradition treaties between states parties. But I also just wanted to highlight again that the offenses with an ICSANT can stand in place of a formal extradition agreement between countries. So just as you've said, it can help to fast track the process where there might not be an agreement otherwise in place. I see we're coming up at the end of the hour here, so I'm going to now move to concluding remarks. Again, Simon, thank you for joining us today, for spending your time with us. I know you're very, very busy, and we really appreciate it. You spoke to some of the key mechanisms related to mutual legal assistance and extradition under ICSANT, and how those can help to facilitate not only the investigation and prosecution of crimes, but also working to prevent these crimes from taking place in the first place. I want to thank the audience again for their time and for joining us today. And I have some good news that we have our speaker set for the next webinar. So please mark your calendars for the 5th of July, where we'll be joined by Mr. Andre Apostol for a discussion on nuclear forensics within ICSANT. Those invitations will be forthcoming, so please stay tuned. And lastly, again, I just want to thank the European Union for its financial support to UNODC, for which our events otherwise would not be possible. So again, thank you for this, and again, for your further contributions to the promotion of the convention. Thank you all, and please have a pleasant weekend. Again, Simon, thank you so much, and we look forward to continuing our work together and continuing to see you all at our future webinars. So thank you.
Thank you very much. Thank you for listening.